Testing 1 2 3. Testing 1 2 3. This is a test of the Seventh Circuit Court of Appeals. Testing 1 2 3.
Good morning, ladies and gentlemen. Our first case for argument this morning is United States against Granger. Mr. Eisenman. Oh, Ms. Eisenman.
Thank you, Judge, and may it please the Court, Vanessa Eisenman on behalf of Eric Walker. I'll be arguing the joint trial issues and Mr. Walker's individual issue. Turning first to the trial, the record is clear that Juror 70 should have been struck for cause because of his admitted bias towards law enforcement witnesses. Again, the test is clear. There needed to be final, unequivocal assurances of impartiality in order for Juror 70 to be seated, and here that did not happen. In fact, this case was really similar to the Thompson case, in which the Juror 70 was very candid, and he said that he would try to be fair. He wanted to be fair. He understood that he should be fair, but he never wavered from his adherence to the fact that because he was a 30-year retired police officer, it would be hard for him not to give police officer witnesses the benefit of the doubt.
Can I ask you a question, though? I mean, looking at the cases in this area, there are two possible ways one could understand what the judge's job is. One possibility, as you're stressing, and we've used this term a lot, is final, underscore in italics, unequivocal assurances. And the last words out of Juror 70's mouth were certainly not any kind of assurance that he would that he would be fair. He was saying, yes, sir, if you want an honest answer, I'd be more inclined to believe a police officer. The other possibility, and I see hints of this in some opinions, is that what the district court judge is supposed to do is kind of look globally at everything that particular juror has said, here Juror 70, and try to make an assessment of that juror's position based on everything that was said, maybe not the last words out of his mouth, literally. So which is it, and does it make a difference here?
If I could answer your latter question first, I don't think it makes a difference here, so I don't think that it's necessary for this court to decide that. I do think the word final has to mean something, so that it is important kind of where it's left. Thompson also talks about not leaving things dangling and said that that was Martina Salazar as well, where kind of like the matter evolved, and then at the end it was really, there was just no great assurance at the end, one way or the other, and that's not enough. But I don't think that it matters here, because I really think if you look overall at what Juror 70 was saying, I think he was really a credible guy, and he was saying, look, the overarching, I think he even used the term, the overarching thing I'm really trying to get at here is that I want to be fair. I want to have an open mind. I want to be, I know I'm supposed to do this. I'm a police officer, but I think it would be hard for me to do that. And I probably would end up leaning a little bit more towards the police officer. So I think it's a good question. And I think, I'd like to say that the word final does need to do some work here. But I think either way you look at it in this case, I think he should have been struck. Again, at the very least, I think we don't have those final unequivocal assurances, and the judge needed to follow up more and say, okay, you said that you would, that you have this inclination. You probably would be more inclined towards the police officer witnesses. Do you think you'd be able to set that aside for the duration of the trial and view each witness the same way? And there wasn't that here. So I think at the very least, the court couldn't leave it hanging the way it was. But I think if you look at the overall, even his just looking at the totality of his responses, I don't think you ever have those final unequivocal assurances. And you can't just pick out one word. I agree with that. Whether it's final or not, you can't say, okay, here's one phrase he said, therefore he's impartial. If you look at it overall here, he was very clear. This would be hard for him. He would have been a great juror for the Thompson trial, right? Employment discrimination. Hey, put him on the jury there and bring the Thompson juror over here. We're not trying to say he would have been disqualified in every case, but this was a case where the majority of the government's witnesses were law enforcement personnel. Juror 70 was chosen as the jury foreman, understandably because of his 30 years experience as a police officer, undoubtedly. And, we don't have to show prejudice, but I think it's pretty clear here that that could have made a big difference. And the defense was out of its peremptory strikes.
Ms. Eisenman, I'm looking at on the record, page 156, 57 of the voir dire, where the court asks the juror, so the question is, can you listen to the testimony here, judge each witness by their testimony, how they present themselves, how it aligns with the other evidence, and so forth? Juror 70 says, yes, because I think the truth is the most important thing here. The court says, so you can do that with an open mind. Juror 70, yes, sir. How is that equivocal?
I think that is equivocal by itself and in the context of the rest of the things that he said. He's not saying here that he's able to suspend his belief in favor of law enforcement witnesses for the duration of the trial. He's saying he can judge each witness by their testimony. I don't know exactly what that means, but that's not saying I view each witness neutrally. And he says he can have an open mind, but then immediately thereafter, even when the judge is still questioning him, he kind of goes back on that and he hedges and he equivocates. And he says, the judge says the same thing. Can you judge each witness by their testimony? I can find the page if you need it. But he says that, no, I think that I can have an open mind, and I believe for the sake of argument that some police officers lie. So even when the judge is still asking him questions, follows up, because that was just his initial responses. The judge follows up. He says, well, yes, I think I can judge each witness by their testimony, but I'll agree, when it's the presumption of innocence, he says, yes, I can do that. When it's this judge each witness by this testimony, he's got explanations. He's referring to his experience.
So I agree that the record, that their statements, I think that can be construed either way, but that's the job of the district court, right? I mean, the district court is there. I've been there many a times myself, conducting voir dire, and the district court the judge seems to me to be in the best position to assess the demeanor of the juror, how the voir dire is going, and to weigh those credibility determinations. And it seems to me that our cases do give quite a bit of deference to the district judge in those circumstances, because we don't have the juror before us now. We weren't there.
I agree with you about credibility, but this is not at all about credibility.
Well, it's a weighing of statements, right? It's about district judges do that all the time, is weighing statements that might be in tension with one another to come to some sort of decision.
Well, but there has to be a line for abuse of discretion too, and you have to have those final unequivocal assurances. Otherwise, the appellate review doesn't mean anything. So what we have here is, if it would have been a credibility issue, if we would have said, he said X, but we really think he meant Y, then I agree with you. We've got to defer to the district judge on those sorts of things. But like in Thompson, this court in Thompson had the same thing. It said, it's important to note this is not about credibility. We believe absolutely everything he said, and we're taking the transcript at total honesty, right? But he says this is going to be hard. He says he's not sure if he can do it. He says he probably would be inclined to lean more towards the law enforcement officers, and we've got to believe that. The judge said he was credible. But it's important, look also what the judge said. He said, I think he will be fair, and I think he will try his best. Okay, first of all, he didn't say he will be fair. He said he wanted to be fair, so that's not correct. Second, he said he will try his best. Try his best is not the standard. We need more than that for the Sixth Amendment right to mean something here. Could I reserve the rest of my time for rebuttal, please?
Certainly, counsel.
Okay, thank you.
Mr. Bont.
Thank you, Your Honor. May it please the court, counsel for the government, I represent Clifford King. In addition to the reasons raised by counsel for Mr. Walker, with which Mr. King fully joins and adopts, there is a further reason that this court should reverse Mr. King's conviction, and that is that the district court erred in denying Mr. King's motion to suppress. In United States v. Zamudio, this court indicated to all courts that there has to be more for the probable cause analysis to mean something than just the defendant is a drug dealer and he lives at a known residence. In Zamudio, this court found that the law enforcement officer's training and experience, which he attested to, formed a belief within the law enforcement officer that other evidence was likely to be found at the defendant's house, and this court held that that was sufficient.
But Mr. Bont, I'm a little bothered by this argument that you've stressed in your briefs, because honestly, next time, if we said every time the police officers say, based on my training and experience, X, you would rightly say that's pretty boilerplate. I mean, of course they have training and experience. And so I'm having trouble hinging very much on that. What I'm also having trouble with, getting down to the nuts and bolts of your argument, is the fact that there seems to have been, in the warrant, at least one transaction in the house. And that's more than, talking on the phone in the house. It's more than just saying he's a drug dealer and here's where he lives and so we're going to search. Isn't that enough to put it over the line? The fact that there was this, I think it was 2 pounds of meth.
Well, answering your second question first, Your Honor, no, I don't think that's enough because that transaction happened a month before the search warrant affidavit was sought. And it also happened during a time frame where the same law enforcement officer who had affirmed the validity of the search warrant affidavit had made a wiretap affidavit application to the district court judge and said that it was unlikely that evidence of drugs would be found in Mr. King's house because he used a stash house. So I think the short period of time, the fact that there's no dispute in the record that drugs were not dealt out of Mr. King's residence. He had an encounter with, I believe it was co-defendant Granger at his residence, and then drove off to a different location 11 minutes later, coupled with the length of time.
But you're not saying that that's not a way of using the house, surely. I mean, it wasn't an intensive use. He wasn't putting his stash there, but house was a point of operations.
It was a point of contact for that lone drug transaction. I will concede that, Your Honor. Addressing your first question about whether or not that sort of boilerplate language is enough, I'd like to see a rule that in future cases the law enforcement officer not only has to rely on his training and experience, but has to say, based on his experience and his exposure to the overall investigation, what is likely to be found in a particular defendant's house. In this case, the law enforcement officer sought the search warrant for Mr. King's house in conjunction with the search warrant for, I believe, 15 other residences at the same time. And it was all based on a 3-month-plus long wiretap investigation where the officer was intimately familiar with each person's role in the alleged conspiracy and what they were doing. So certainly he had the background information where his training and experience would have meant something, and he likely would have been in a position to say what was likely to be found in Mr. King's house, but on this record, he just didn't do that. And I think that under this court's holding in Zamudio, there just needs to be more, and there wasn't in this case. Remand for resentencing in Mr. King's case is also appropriate because of 2 errors that the district court judge made at sentencing. The first is that he extrapolated the detailed recitation of the drugs that were involved in the conspiracy in the PSIR. Based on ambiguous testimony from the cooperating witness, wherein she stated essentially that on some occasions she received a pound of methamphetamine from Mr. King. On some occasions it was more than that, and there were some days where there was no transactions taking place at all. This cooperating witness also had an independent dealer. The record was clear that Mr. King was not her only source of supply. And the record established, based on that months-long wiretap investigation, that there were, in fact, weeks where she and Mr. King did not conduct transactions. So to take her testimony, which was equivocal on that point, and say that it establishes a 1 pound per day amount for Mr. King.
But she actually testifies to quite a bit more for some days. Some days she said 2, 3, 4, maybe it's 5 pounds. That's a lot of meth. And so smoothing it out, the district judge thinks he's being generous, actually. He says this is really an understatement from what evidence he was hearing.
The record does indicate that the district court judge thought that he was being generous. However, and again, the PSIR laid out a very detailed recitation that matched the trial evidence, and this is an investigation that went on for 4 months. So they knew that during that 4-month period, there was one day where, in one transaction, Mr. King and Mr. Granger met with the cooperating witness and dealt 3 pounds of methamphetamine. There was one day where that happened. There wasn't multiple days. And again, this is a cooperating witness. So the judge had the opportunity to hear all the witness testimony, but that is what the record established. So I don't think that the district court judge was in fact being generous when he made that extrapolation. And again, this is the highest base offense level for a drug dealing defendant. And so I think more is required before a district court judge can arrive at that level. And then lastly, the district court judge also enhanced Mr. King's sentence by 2 levels for possessing the same firearm which formed the basis for a separate count of conviction for which Mr. King was separately sentenced, which this court held in United States versus Bustamante is improper. So that's another enhancement, and the combined effect of those enhancements that the district court erroneously made would have made a difference to Mr. King's sentence. He would have been in a different guidelines range. So, Your Honors, if there are no further questions, I'll just reserve the remainder of my time and pass the argument to Mr. Groman.
Certainly.
Thank you.
Mr. Groman.
Thank you, Your Honors, and may it please the Court. My name is Chris Groman, and I'm arguing on behalf of Mr. Derek Granger. I'm here not only joining the issues of co-counsel, but also arguing that the government failed to put forth sufficient evidence to convict Mr. Granger of what they actually charged him with in this case, which is conspiracy to distribute methamphetamine, not merely distributing methamphetamine. The government points to several factors that came out of trial that the government believes shows that Mr. King and Mr. Granger had an agreement to distribute methamphetamine, meaning that they were on the same side of the transaction.
So Mr. Groman, correct me if I'm wrong, but I thought that the district court did give a buyer-seller instruction in this case.
That's correct, Your Honor. But the buyer-seller instruction doesn't cure all. The district court and this court still needs to evaluate whether or not there was sufficient evidence put forth at trial for a reasonable jury to conclude, even with the buyer-seller instruction, that there was a conspiracy here. And I don't think they've met that standard. Let's just sort of briefly talk about what the government points to in its response brief. First, they point to the fact that Mr. Granger gave drugs to Mr. King knowing he was going to resell it. That's how every transaction works, unless you're giving it to somebody who's actually going to use it. As this court pointed out in Lechuga, just giving drugs to somebody knowing they're going to resell it is not enough. Second, they point to the repeated nature of the conduct between Mr. Granger and Mr. King. Again, there could be arm's length sales each time. Just the fact that they constantly deal with each other is not enough to show conspiracy. And last, they point to the March 4th, 2020 conduct where Mr. Granger accompanied Mr. King to meet with Ms. Dowling, and that was clearly on credit. But again, one transaction that's on credit is not enough to show a conspiracy, especially in light of the fact that Ms. Dowling testified that she paid cash 50-50.
Half the time, yeah.
Yeah, there's no evidence of what the arrangement was between Granger and King in terms of credit, other than that this one single incident was on credit. Lastly, the government points to the fact that Mr. Granger helped Mr. King in that particular transaction. I'm not exactly sure what help he provided based on the record. He certainly accompanied him there, but he didn't count the cash. He didn't give the drugs to Ms. Dowling. And in summary, there is just simply not enough here for a reasonable jury to have concluded that this was a conspiracy as compared to merely a buyer-seller arrangement. Thank you.
Thank you, Mr. Groman. Mr. Wright.
May it please the Court. Brian Wrights for the United States. I plan to progress through the issues in the same order that the defendants did, starting with the juror issue. On that, Judge Wood, I want to start right with your questions. I think that gets somewhat to the crux of the matter. The analysis is global. In other words, it's not the final assurances is not a literal last-in-time requirement. For that,
Why is the word final used then? I mean, there's been a discussion, and if at the end of the day the person winds up saying, in summary, I'm going to give more credibility to the police officers. It didn't quite say that, but it sounded like it.
So we have a specific and a general reason why it is global. First, specifically, we would point the court to Griffin v. Bell. The same chronology there occurred. The two jurors said they would most likely, I'm paraphrasing, but most likely believe the police officer. Then the court inquired, and they gave assurances at that point that they could be fair and impartial. The defense attorneys then questioned them, and they went back and said, probably would give more credence to a police officer. The court did not say that those jurors were improperly seated, even though their final statements were equivocal. So based on Griffin, that's a specific case where the final does not mean literal last word. And I also want to talk about the general standard. I think from the standard review from the Supreme Court and this court, I think really conflicts with that final, because judges, or first of all, courts or jurors understandably are not required to be consistent or clear, and some wavering is acceptable. Judges can value statements made to them more than other statements. Judges can discredit statements made based on leading questions. And so all of those, I think, factor into the idea that the judge is not required to hyper-focus on the very last statement. If that was true, then I don't really know what the discretion the judges would have. They would really...
Well, to interpret that last statement, but what bothers me is looking at Juror 70, he keeps coming back to this theme. You know, I was on the force for 30 years. Police officers are vetted. I didn't think the government's explanation of what that meant was overwhelming. And he keeps saying, you know, they're trained to tell the truth. And I, you know, the bad apples, he more or less says, you know, have been weeded out by the time they've been on the force for a while. This isn't just a stray statement that he makes at the end of the discussion that conflicts with everything else. It's a theme.
There is no doubt, and we are not here arguing that the juror didn't have an inclination or pro-police beliefs. That I would step back and say I would caution the court to think about that, because it would be hard in my mind to write a rule here that wouldn't essentially exclude all retired police officers. Because I think police officers that are being honest with themselves are going to have similar views to this. I think it's a natural, innate human instinct to value in-group statements over out-group statements. So I think that you're going to have police officers say things like this a lot. And this court or no court has ever said that prior employment or even current employment...
No, I don't think that. I mean, but some people do manage to say, I'm not going to go in with any priors about which witnesses are credible and which aren't. I'm just going to listen to the testimony. That's what you want. I mean, look, if you read the newspapers, I would suspect that there are some people who might be on a jury of an ire who would say, if it was a police officer, I was assuming he was lying.
As an aside, we actually recently had one of those, and that juror
Okay.
wasn't struck for cause. We had to use a peremptory. So I think it does work
It
both
could happen
ways.
either way.
Yes, but those either way are prior beliefs, not biases. So, and because of that, we can look to whether it was unequivocal statements.
What's the difference between a prior belief and a bias, in your opinion?
I think what this court said in Thompson, a bias is unshakable, adamant, irrational. In fact, something like, no matter what I hear, I'm going to believe the police officer. And that's not what the juror said here.
No.
He admitted that some police officers lie.
He said for the sake of argument.
He said more than that.
It was a pretty weak admission, if that's what it was.
That wasn't the only one, Your Honor. In his first statement, without any pushing, he said, "So yes, police officers lie," and pointed to issues in the news. He said the majority take their oath seriously. All that left room for the possibility that some did not, and that is not irrational or adamant or unshakable. So therefore, we can look to what Judge Lee pointed to. There were unequivocal assurances. In the colloquy with the judge at 155 to 157, the juror said there was no presumption with any witness. He said that he can have an open mind. He said he could judge witness credibility based on their testimony. That is what we're looking for. And when there are two categories of statements, and there's no doubt there were some statements pro-police, some statements that the juror could keep an open mind and judge the evidence impartially. The district court is in the best position to weigh those statements. That is a credibility determination, and that is very difficult, I think, under the standard review for this court to reverse. If there's no further questions on the juror issue, I think I can briefly move through the remaining issues. The suppression issue, Mr. King, I think it explicitly contradicts Zamudio. Zamudio says there does not have to be a direct link between the location and the evidence of the drugs. Drug dealers, trial courts can presume that drug dealers store evidence of their drugs or of their crime at a residence. And here we actually have more than that. We have a drug dealer.
You do. Let me just interject, though. I'm a little worried about the momentum of this idea that drug dealers are likely to keep evidence of their business, so to speak, at their residence, because we have said that you need more than that. You need more than just saying Jones is a drug dealer, therefore we can search his residence. And I'm not sure what that more is, because the government keeps coming in, and certainly I don't think it could mean that if the police officer just encants, and by my training and residence, I expect to find evidence. That, I mean, I just think that's silly. But maybe we have more here. But I don't know what. I'm very worried that it's turning into just a per se rule.
Let me start by saying we do have more here, so I'm not sure that's an issue for this particular case. On the other, I argued Zamudio, and not to put myself in this case again, but I was asked that question, and I still think it's difficult to conceive of the situation that rule wouldn't apply. I think you would probably need evidence in a wiretap that would preclude or exclude any inference that the drug dealer had any evidence at his home. I think without something like that, the inference is, to me, so obvious that criminals likely keep some evidence of their crime at their home that there almost has to be something in the record that would dispute that. I think if it's
not even clear to me that that's true, though. I mean, because a lot of this business is done using cell phones, and if you're just standing there in your house talking on the cell phone, I don't know why that leaves a footprint, in the house. I mean, something's in the air and it's bounced up onto a cell tower, so that's not your home.
Well, the cell phone itself is attribution evidence, I would say.
Yeah,
so we got to wire.
But most people have their cell phones like surgically implanted into their hands. They're never away from them. I'm probably one of those people half the time. But
I think we all are like that, but. Beyond the cell phone, there are drug ledgers. I don't think we should presume that all drug ledgers are electronic. If they are electronic, they might be stored on a computer. I think there's just a lot of evidence that might be relevant.
Isn't that speculative? I mean, again, if you're using, the cloud to store these things, you have some appropriate passwords on stuff. In today's world, it's just not clear to me that you can just say he lives here, therefore there's going to be evidence. You seem to be flipping the burden, saying, no, he has to say, well, actually, I have 3 young children at the house. I take every effort, not to do anything in my home, something like that.
I don't intend to be flipping the burden. I just think the inference is so strong. And really, that's what the court has said for years. I mean, Zamudio didn't come out of the blue. Zamudio is built on years of precedent. I really think that's the scenario we're looking at. I don't. There may be others. Maybe Your Honor is onto something with there's no evidence that he does anything but speak on the phone. Maybe then, sure, maybe then. But if it's a normal mine run case like here, actually this is above the mine run case because we have a drug deal occurring.
Well, you have the drug deal at the house, which
Yeah.
I recognize makes this not the case that I'm even more worried about.
Yeah, we aren't fighting against the idea that it's a blanket rule. I just think that the inference is so strong. The blanket is covering most of the bed, maybe mixing metaphors.
Mr. Reitz, can you address, before we leave Mr. Walker, one of the issues that Mr. Walker raised was how the district court calculated the drug quantity amount.
For Mr. Walker.
For Mr. Walker.
Right, so we think there are 3 ways to get there.
No, I understand you think there are 3 ways to get there, but the way the district court got there was he basically attributed the entire conspiracy, or what he calculated to be the entire conspiracy amount, to Mr. Walker without doing some additional fact-finding with regard to either foreseeability or other factors that the sentencing guidelines would prefer that he do.
I think it's fair that unlike Mr. King's drug quantity, Mr. Walker, the way the court did it is based on an inference. So what we can say, we know that for the short period of time when the wiretaps were in effect, Mr. Walker dealt a significant amount of drugs. I think we can also say, based on his early wiretaps, his status in the conspiracy was pretty long-standing. The first wiretap, so we got a wiretap that went on February the 6th. 3 days later, Mr. Walker is on the wiretap with Mr. King, instructing him about a customer payment. The next day, he's telling Mr. Walker, you had a warrant, don't pull a gun. 3 days later, he's telling Mr. King how to play Miss Adams and use her until she's arrested. So there's certainly an inference that Mr. Walker's involvement in the conspiracy lasted well before those 6 weeks.
But
and we know that
what is the best evidence that, to the extent that the certain drug quantities can be attributed to Mr. Granger, that they should also be attributed to Mr. Walker? Right, because the evidence is that Ms. Dowling, Mr. King received drugs from both,
yes.
right? And so, what's the evidence that various quantities could be segregated out with regard to Mr. Walker versus Mr. Granger?
It does take some reasonable extrapolation, but I'll point to two things. We do know Walker knew there was another supplier. There's a comment on a wiretap to Mr. King that indicates as much. And I understand the defense has a problem with it, but during the time period of the conspiracy, there was a photograph of the three together, which supports the idea that Mr. Walker knew of another supplier.
One
and
picture? I mean, really, that seems a little crazy.
I don't. If that is our proof beyond a reasonable doubt, certainly I think that's pretty thin. But it's sentencing preponderance the evidence when you factor in the phone call that Mr. Walker identified or acknowledged another supplier. It stands to reason that if he's pictured with the other supplier and Mr. King during the time frame of the conspiracy, he might not know it's Granger. Though, of course, he doesn't have to know who the supplier is. It's whether it's reasonably foreseeable that there were more drugs coming into the conspiracy, and Mr. Walker, it was reasonably foreseeable to Mr. Walker that more drugs were coming to King than just him because he knew there was another supplier.
Well, there are actually several other suppliers.
Well, correct.
But, so did you search the phone to see who else he had pictures with? He must have had pictures with tons of people.
Yes, I mean, going back to Your Honor's point, our phones are attached to our hands and we have pictures of a lot of people. But I think it is, again, not beyond a reasonable doubt incriminating, but
Pull out this
but
one.
you,
Okay, go
I think three members, the three top level members of the conspiracy, pictured together during the course of the conspiracy is indication that they know each other and are working together. Again, we're not saying that by itself proves beyond a reasonable doubt, but we have to prove preponderance, that it's reasonably foreseeable, and I think that's an indication that Mr. Walker knew there was another drug supplier, and that made it reasonably foreseeable to him. I would add that I don't...
A lot of inference in there, I just have to say.
I started by saying, unlike Mr. King, I think there's an inference based on an inference. I would step back and say, if the court is unhappy with those inferences, we would just point to the drug weight and the fact that he dealt 16 pounds of drugs and it was 95% pure.
Yeah, but that argument, I mean, as Judge Lee was saying, that wasn't remotely what the district court relied on.
Correct. We advanced that argument. That's not what the district court did. The court can affirm on any grounds. I think that's a clear ground in the basis, or ground in the record. We argued it, and Mr. Walker didn't respond to it in any way. And I think it's pretty hard to respond to, other than this idea that the court should reject the guidelines based on a policy argument. But of course, Mr. Walker didn't make that argument below, so we would say that's waived. It really only takes two things in the record for us to get over the limit for level 38. That's one, the amount of drugs that Mr. Walker himself dealt. I see no argument that that's not the correct number. And then the purity levels, which the drugs down the line were that pure. I don't see any argument that that was incorrect factually. So you put those two together, and Mr. Walker clears the level 38. I think that's a cleaner way. That's, if I was the court, that's the way I would have done it. I don't think the way the court did it was wrong. I think the court could have also picked the third way. But if the court is worried about the inferences on extrapolating to the reasonable foreseeability of all the drugs, I think the court can definitely look at the purity argument. Just briefly on Mr. King's drug quantity, I alluded to that. His is based on actual testimony at trial. Mrs. Dowling, sure, she said 0 to 5 pounds. It only has to be, the judge put it at a pound, which I think was conservative. That was 3 times more than the level. So it actually has to be less than 1/3 of a pound a day for a year for Mr. King to go down an offense level. And I think if that was the case, we might have appealed, because that would have been an unreasonable clear error factually. I think one is a conservative estimate that's well supported by the record. The gun bump, we think, is different than Bustamante. Of course, it doesn't matter if the drug quantity is right, because those two levels don't impact his guideline range. So I would understand the idea the court maybe doesn't want to mess with the edges of Bustamante, but the court can easily find that that was harmless error. There's nothing on that Mr. Granger's sufficiency argument. I think the March 4th transaction says everything. Mr. Granger helped King transport drugs to a drug deal. There, he oversaw as the drugs were resold. I think Mr. Granger's reply brief on page 2 essentially admits as much. He says it's a one-off where he went with King to make sure the drugs were resold. That's a conspiracy because he worked with a middleman to sell the drugs further down the line. If the court has no questions about the issues that were unraised at argument today, we're happy to address them. Otherwise, we would rest on our brief for those issues. Thank you.
Thank you, counsel.
The court should affirm.
Ms. Eisenman, anything further?
Just two quick things. First of all, the government's contention that if you, couldn't strike or had to strike juror 70, in this case, you would have to strike all cops with this much experience. I vehemently disagree with that. This was a detailed discussion. This was a juror who was grappling honestly with the fact that he personally didn't think that because of his personal experience, he could set aside that. You could imagine tons of different scenarios where police officers with the same amount of experience would be able to say, you know what, yes, I had that experience, but I think for this trial, I could set that aside. That did not happen here. And Thompson says, if you don't have those final unequivocal assurances of impartiality, you don't defer to the district court. You reverse, you get a new trial because the Sixth Amendment requires an impartial jury. Second point, just on the drug quantity. Again, we're forgetting the standard a little bit here. Helding says that district courts, when they're calculating drug quantities, they have to take care in making these determinations. The government's got tons of reasons why this should be upheld, but this court is not in the business of calculating drug quantity. The district court has to do that work. The district court did not do that work here. All the district court said was based on Dowling's testimony, but as Judge Lee pointed out, Dowling didn't know who the suppliers were. King had multiple suppliers. There were 3 different meth suppliers. There was no evidence that Walker was involved beyond those 16 specific transactions. We have 16 transactions.
Thank you,
Why
Ms.
are we
Eisenman.
extrapolating? Thank you, sorry.
Mr. Bond.
Thank you, Your Honor. Very briefly, in conclusion, I think Zamudio clearly indicates that something more is required, and the record in this case reflects that the only something more in this case is one 14-minute meeting with Granger that took place 1 month prior to the application for the search warrant. I think in my opening I may have indicated that it was 1 month prior to the search warrant actually being executed, but it was in fact 1 month prior to the execution for the search warrant, or the application for the search warrant, sorry. And again, that was during the same period of time when the same attesting officer said that it was unlikely that any evidence of drug distribution was likely to be found at King's house because he uses a stash house. So for those reasons, I think this case is different, and I just don't think that's enough. Thank you.
Thank you, Mr. Bond. Mr. Grumman, your time has expired. The court wants to express appreciation to all 3 of you, Ms. Eisenman, Mr. Bond, Mr. Grumman, for your willingness to accept the appointment in this case and your assistance to the court as well as your client. The case is taken under advisement. Our second case of the day is AC against the Martinsville School District. Mr. Zimmerly.
Opposing counsel, Chief Judge, may it please the court. The statutory safe harbor at the crux of this case, 20 U.S.C. Section 1686, allows schools to maintain separate living facilities for the different sexes. This court and the district courts below have never expressly addressed Section 1686.
But I don't understand anyone to be contesting that. They all say, fine, separate facilities. This case is the next level down. How do you sort, basically? It's not separate facilities. So it seems to me you're arguing about something that's not an issue.
Your Honor, we would contest that that is what is at issue. Ultimately, the schools are seeking to maintain those separate facilities based on sex.
Well, but can't you see how you're eliding the question? The question is, what does that require? You know, how do you sort? Who belongs in the boys' room? Who belongs in the girls' room? And what indicia do you use for that? Your position is that you use the sex designation on the birth certificate, as I understand it. The position of the plaintiffs really, we have the two cases together, is that you use the gender designation that the person uses. Those are two different ways of sorting, and it seems to me that's the issue before us.
Your Honor, that may be the case in terms of, yes, the position that's being taken by the plaintiffs is that they should be allowed access to the boys' restrooms and locker room based on their gender identity.
Because they're boys.
That is that is how
I
they
mean, that's their
identify as
position. I know
boys.
it's not your
Yes.
position. I don't want to put words in your mouth, but their position. So isn't that what we need to zero in on? How do you sort? It's not like you've got to abolish all the boys' restrooms in the schools. Indeed, they would be very upset if you did.
Yes, Your Honor. Our position is that the court needs to look at the statutory text in light of Bostick, and that the court must address the safe harbor and apply it. In doing so, this court should revisit Whitaker and reverse the orders that were entered below. Specifically with regard to Title IX, we believe that it's important to look at the statutory text and that the court has to follow that statutory framework that's set by Congress. In doing so, it's important to recognize the guidance that's given by the Supreme Court in Bostick. And in Bostick's a Title VII case, and there the Supreme Court declined to extend its ruling to the facility context in either Title VII
Right,
or
you're quite
Title
right.
IX.
It leaves that issue open, but the court does say in Bostick that if you're just talking about classifications, a classification of a transgender person is inherently one based on sex. Now, what you do about that, what the other parts of Title IX may say, again, you know, I recognize the court has signaled we're not saying yes, we're not saying no, we're just saving it for another day, which they do all the time. You know, that's fine. That's their job, right?
I don't quite understand if you're asking me a question, Your Honor.
I'm just saying that we do get some guidance from Bostick about how we should think about the transgender classification, because the court says in a very simple declarative sentence that to classify on the basis of gender identity is inherently to classify on the basis of sex.
Yes, correct, Your Honor. And the court also said that
And we're not really free to disregard that, are we?
we're not free to disregard that, but the court also said that homosexuality and transgender status are distinct concepts from sex. And in looking to the statutory text then in Title IX,
Well, they're derivative of sex, though. I mean, I use the words you want. I'm happy to use the words the Supreme Court used. I don't know that I should rewrite their opinion.
so
That's higher than our grade level.
right. So the court is to look to the statutory text. Title IX begins in 1681 with a prohibition on discrimination based upon sex. No person shall, on the basis of sex, be subjected to discrimination under any education program or activity.
I have a factual question. Other than Whitaker and the decisions in the 4th and 11th circuits, have other circuits tackled this issue?
Your Honor, the Sixth Circuit did in the Dobbs decision that we've cited to the court only in the context of whether or not to stay a preliminary injunction that had been entered below. So we've cited to that case as well.
Not a final decision. So the answer is no.
No, Your Honor.
Okay.
And in going back to the statutory text, Whitaker focused on 1681, but that's not all that Title IX says. In enacting Title IX, Congress created several express exceptions to that general rule based upon the differences between the sexes. Specifically, Title IX allows for separate living facilities based upon sex, and it is an interpretive mandate where it says interpretation with respect to living facilities.
So, counsel, getting back to this idea that Judge Wood raised about sorting. So, as I understand it, all three plaintiffs now have birth certificates that designate them as male. Is that correct?
That's correct, Your Honor.
And so, presumably, the state of Indiana, the judiciary at least, has ordered that their birth certificates be designated as male. What, if any, bearing should that have on our decision?
Your Honor, I don't think that it should have any bearing on this court's decision.
And if you don't, then who decides? So if the court, right, you have a birth certificate, let's say you have a new enrollee come into your school system.
Yes.
And they present a birth certificate and it says, I am male. Is it the school's role then to sit back and say, well, I don't know, because you don't really look all that male to me. Prove to me that you're what we think is male, right? Is that how the system should work?
That is not the way the system should work, and it's not the way the system works. In this particular instance, when the students enrolled in the schools, they enrolled with their sex indicated as female.
So let's say these students then enroll in the neighborhood district, okay? And now they have a birth certificate, right? And so then under your rules, then in the other school, they should be allowed to use the restrooms, right? The boys' restrooms, because now they have a birth certificate that they've shown to their new school. So what you're saying is just a matter of when someone applies to a particular school system. Doesn't that seem rather arbitrary?
No, Your Honor. And in that particular instance, the hypothetical you presented, I would suppose it would be based upon whatever policy that particular school had, what they would look at.
And so if another transgender male student came into your school system and had a birth certificate that designated that person as male because they received a court order the year before they moved into your school district, under the rules of your school district, you would allow that student to use the boys' bathroom.
I believe that would be the case, Your Honor, so long as the school didn't have any other indication that somehow their biological sex was other than was indicated on their birth certificate. So, Your Honor, look into...
That's an interesting position. So you would let them use, it seems to encourage, I don't know, let's say a lack of disclosure, because if the person comes in with sex designation already saying male, you're saying that you don't require them all to go to the health clinic and strip them down and take a look and see if you think they are male. You accept that. If a parent or guardian goes to the counselor and says, there are other, psychological challenges or challenges that the person is having, it would behoove them not to reveal to the school district that the reason the designation is male is because of a court order, not because of what happened at birth. That seems it seems like a very arbitrary line you're drawing.
Well, Your Honor, I don't know that instance has ever come up before the court, and so it would present separate facts for the court, for the school district to deal with in that particular situation.
But counsel, wouldn't that situation also just undermine the government interest the school claims it has? If your policy would allow, transgender students to use the bathroom of their choice, new students, and wouldn't screen them otherwise, what about all of the concerns that the school raised in the briefs about privacy concerns, about other students, and all of these other kind of interests the school claims it has? It would seem to undermine the school's position, the district's position, that all of those interests are so important that it would require this policy.
Well, Your Honor, I don't know that the privacy interest here is in question. It's a privacy interest that's been recognized by the Supreme Court in United States versus Virginia, by recognizing that this court...
I'm not quibbling about whether or not it's a valid governmental interest per se. I'm just saying in this instance, your policy, the justification you provide for the school's policy of using birth certificates in this particular instance with regard to these three students is that it would infringe upon the privacy interests of other students. Yet the same policy would allow newly enrolled transgender students to use the bathrooms of their choice. So in those instances, the policy justifications, I suppose, wouldn't really come up or wouldn't really be valid.
Well, Your Honor, in that hypothetical that you presented, all the indicia that the school has received at that point in time is that this student is the biological sex that appears on their birth certificate.
And isn't there an empirical question here? I mean, on this record, maybe on some other record it would look different, but on this record, it appears that the school, that the boys' rooms in the school have a certain number of stalls, that it's quite possible to respect everybody's privacy, including that of the transgender students, or maybe somebody else who just prefers to handle things privately. I suppose if you had a boys' room where there were no stalls whatsoever, maybe there would be a privacy interest because you would be exposed to someone's body in a way you didn't want to be. But I don't know. I'm worried that there's an empirical quality to this argument that's not being recognized.
Well, Your Honor, this does raise separate issues that were raised in Whitaker with regard to the physical spaces that are at issue. With regard to Vigo County, the locker rooms and their showers are such that they are wide open spaces.
Well, and the showers were excluded from the district court's injunction.
That's
the
correct.
District court's injunction does not require you to allow them to have access to the shower, the people in question, the two in question. So it seems to me that issue's not before us. It's not in the injunction.
That's correct,
The
Your
only
Honor.
thing that's in the injunction are places where there are privacy stalls available.
Well, and the locker rooms that are wide open spaces, while the plaintiffs have indicated that they will use the stalls in the locker rooms, there's nothing in the preliminary injunction order prevents them from having unfettered access to the locker rooms themselves. And with regard to those spaces,
But there are stalls in the locker rooms. So if they're changing their clothes, I mean, I think they're just changing into gym suits. I don't know why they're changing their clothes in a way that would compromise anyone's privacy.
Your Honor, in with regard to the position we're taking here, we're looking more deeply at the other sort of ramifications for this court's ruling as it relates to...
And it didn't happen during the couple of weeks that the plaintiffs were using the boys' rooms. No untoward incidents. It was just a staff member who was worried about it.
That's correct, Your Honor.
Which is exactly the same as Whitaker.
It's very similar to Whitaker in that respect, Your Honor, but our position is that the statutory scheme was not addressed by this court in Whitaker, and ultimately this court needs to look to Section 1686 and the regulatory framework, because there are all sorts of implications for this court's position if a student is allowed to use a restroom or a locker room or a shower space based on their gender identity rather than their sex. It has implications with regard to residential hall bedrooms, with regard to sports, with regard to the...
Shouldn't we take a page from the Supreme Court and just decide the case that's before us? I mean, it seems to me maybe there are different arguments that would be made in those contexts. I'd be perfectly happy to be modest.
Your Honor, this court cannot disregard the fact that there is this implementing regulation and the statutory scheme, and that whatever this court decides in relation to this case has implications with regard to those other cases that would be coming before the court. And so what the court sort of characterized as a simple request in Whitaker has far-reaching implications with regard to all other aspects of the educational space. I see that I'd like to reserve the remainder of my time. Thank you.
You have 40 seconds left. Mr. Falk.
Good morning. May it please the court. These cases are, of course, controlled by Whitaker, but there are some facts here which are different than Whitaker. Martinsville allows transgender youth to use restrooms consistent with their gender identity at the high school level. So all the concerns about privacy that are raised in this case by Martinsville make no sense. They have conceded them already for transgender students. Now, Vigo County has a written policy that's in the record at 43-2 in the district court record that purports to allow transgender students to use the restrooms consistent with their gender identity. But during a deposition, they said, oh, and by the way, they also have to have surgery. Well, you can't have genital surgery under the age of 18. But
That's a very common rule, isn't it? I mean, I gather that's an Indiana
course.
rule, but it seems to me it's quite normal.
yes, my understanding is that because of who is making the decision for whom, that the doctors will not do that, and it's not recommended prior to 18 for the genitals surgery. So we don't have a situation like Whitaker where it's never been discussed, never been thought of, never been heard about. Here we have two school systems that have concretely determined there might be situations where transgender students can, and in Martinsville actually do use the restroom. So we're even further along than Whitaker, and as Judge Wood noted, Whitaker has been strengthened. It's been reinforced by Bostick. Bostick, of course, a Title VII case, but in Bostick, the court said clearly that if a person is discriminated against who's transgender, it's unavoidable that they're being discriminated because of their sex identified today as opposed to when they were born. And that's Whitaker. That's making a decision based on gender nonconformity. That's exactly what Whitaker held. And as Judge Easterbrook noted, yes, there is a split in the circuits. The 11th Circuit recently went the other way. But of course, in Grimm, the 4th Circuit followed Whitaker. And we do have also the 3rd Circuit in the Boyerton Area School District case, which denied a preliminary injunction to cisgender students who wanted to block transgender students having access to restrooms and locker rooms, saying that would be a Title IX violation, potentially. So it has been spoken to in those regards. But there's no reason to reconsider Whitaker. This is on all fours with Whitaker. Locker rooms, different than bathrooms. However, this is a preliminary injunction. We have to look at the record. And as Judge Wood noted, the record in this case is that they are not going to use the showers. In fact, the boys indicated in their affidavits that no one uses the showers to the best of their understanding. They'll use the stalls. Other people can use the stalls.
So what's in the record about a commitment on their part to use the stalls, you know, when they're changing their clothes into their gym outfits?
And Your Honor, I apologize. I'd have to go back and look. But I think they were always quite clear that they were never in any way interested in looking at any other people. They want to get in and out as quickly as possible, but they want to get in and out as boys. Okay. And again, the cases that have been brought, like the Boyerton case or the Parents for Privacy case, where students or parents have brought challenging transgender students having access to bathrooms and locker rooms, have all said, look, the school can make some sort of accommodations for them. They can go to the nurse's restroom and change and go to the bathroom. You can erect shower curtains or what have you in the shower if that's what you want to do. But you cannot put the burden on the transgender student, because that only aggravates his gender dysphoria. And the record in the case is absolutely clear. There is no contrary evidence to this record that disputes the fact that we're being denied the access to this most basic form of their development and their social transition. Use of male facilities was extremely harmful, both physically and mentally, to these.
So could I just confirm, we have, I think Whitaker itself recognizes, but it's been recognized as far as I know, that it is perfectly all right for the school district to require documentation of the gender dysphoria diagnosis, that this isn't just some frivolous, you know, hey, I want to go to the men's locker room and scope out everybody, you know, that school can have criteria that it follows.
Of course, like anything else. I need to be excused every 15 minutes to use the restroom because I have some sort of medical situation. Well, the school doesn't have to listen to that unless there's medical documentation. And here, there's no doubt that the three boys are receiving gender-affirming care through Riley Gender Health Clinic. And the other thing, Your Honors, is looking at the boys in BE and SC. They've been on male hormones since November of 2021. And the evidence is clear that after a year, you develop male characteristics. I have not seen them, but the evidence is that generally you get a beard, you have muscle changes, you become male. And for some reason, it seems odd that the schools are saying we want these boys to be in women's rooms, in girls' rooms. I would seem to me that's where the privacy issue is. They're not girls, and Whitaker recognizes that. And if the school feels there's other evidence, they'll have plenty of time to bring it to court. These are preliminary injunctions, but the record in this case is clear. The district courts properly followed Whitaker, and there's absolutely no reason to overturn Whitaker. And I would point out the school keeps asserting 20 U.S.C. 1686, which concerns separate living facilities. These aren't separate living facilities. They're separate toilets.
So you would concede that we can save for another day some of those issues?
Of course, Your Honor.
Yes.
Of course, Your Honor. But although the school has...
Asking a lawyer whether he would like to engage in more litigation seems an odd question.
It's what we do, Your Honor. But
Indeed so.
But the bottom line is Whitaker remains good law. And the schools have never come out and said, we want you to overturn Whitaker.
Well, this case may be on its way to, or this case, or the 11th Circuit's case, or somebody's case might be on its way to the Supreme Court.
Yes.
And it's unclear what we can do to improve the Supreme Court's understanding of the issue.
I agree, Your Honor. But as far as the Seventh Circuit is concerned, the Seventh Circuit spoke in Whitaker, and this is Whitaker with actually better facts. Thank you.
One might think that the 11th Circuit's en banc decision already provides all of the options the justices might want. And then some.
One might.
It is interesting that the 11th Circuit never once mentions this court's decision in Whitaker. So the line has been drawn. Thank you, Your Honors.
Thank you.
Mr. Zimmerly.
Yes, Your Honor. What this court can provide in terms of further guidance is looking at the specific statutory text and the differences between what appears in Title IX versus Title VII. Title VII, which this court applied in Whitaker, isn't concerned with facilities. It has no statutory safe harbor similar to Section 1686, and it doesn't have the sort of implementing regulations that we've applied here. And so what we've asked the court to do is to look at that statutory text and the implementing regulations and apply it to the facts of this case where there is no dispute with regard to the biological sex of the students being female. For these reasons, Your Honor, we respectfully request that the court reverse the preliminary injunction orders entered below and remand. Thank you.
Thank you, counsel. The case is taken under advisement. Our next case for argument this morning is Shaw against Illinois Sports Service. Mr. Harper. Mr. Harper.
Good morning, Your Honors. May it please the court. This case arrives at the court on a ruling on summary judgment. The judgment should be reversed and remanded because the movement failed to meet its burden. Here, there's a genuine dispute regarding a material fact. That fact is, what are the essential functions that Mr. Shaw would have had to perform and which the Porter position that he applied to is governed by. This issue was simply a motion like any other. I realize it's summary judgment. I realize there's a tendency to view summary judgment sometimes differently than other motions, but it's simply a motion. The movement has a burden. The movement has to satisfy its burden. The burden is set forth under Rule 56. It says, the court shall grant summary judgment if the movement shows that there's no genuine dispute as to any material fact, and the movement is entitled to judgment as a matter of law.
But if you're hanging this whole thing on the affidavit that was furnished by the person, I don't see where there's a clear statement in that affidavit that Mr. Shaw is able to perform with or without an accommodation. You're not supposed to have an accommodation that amounts to another person by your side all the time. And it's just very vague about what kind of training the expert thinks he can do, how long that will take, how can he read and interpret the delivery forms and purchase orders, how can he perform the basic arithmetic that he needs to count the inventory. I just don't see where in this record there's any evidence that a rational trier of fact could credit that would satisfy those requirements. It's a very sad case. I mean, it's terribly sad, but that doesn't necessarily mean that Sports Service has to hire him.
What Your Honor is referring to the expert's affidavit.
Well, I thought that was what you were complaining wasn't fully taken into account, because otherwise, the district judge assesses the evidence and says that just no rational jury could find. Actually, the district judge gives you the benefit of the doubt on the eligibility criteria, which I think could be argued about too, but let's put that to one side and look at his ability to perform the basic functions of the job, and even that, I just don't see where's the evidence.
Well, Your Honor, actually, the position that I was taking starts at a different point. Your Honor is moving into the analysis of whether Mr. Shaw can perform the functions, and my analysis actually begins a step earlier. What I'm saying is that there's actually a dispute about what the essential functions are. And so with that dispute, this isn't simply a material fact, what the essential functions are, but it's a dispositive fact. Under the statute, it is the test that the court will have to apply. The statute under the Americans with Disabilities Act requires the analysis of whether the employee can perform the essential functions with or without an accommodation. In order to apply that test, we have to know what the essential functions are. And so identifying the essential functions isn't simply a material fact, it is dispositive. I might go so far as to say that it is perhaps the sole dispositive fact, and yet that is the fact that here, it's not only in dispute, it's not only that there's a fact issue regarding that fact, but the fact issue is created by Sports Service's own evidence. It's not like we hired an expert who came up with some theory that there ought to be an analysis of the essential functions that differs from what Sports Service's job description says.
I just don't, be concrete. What job function? I mean, this is part of your theory that there are really two jobs, not one?
Yes. Right. Well, it's not my theory. It comes from Sports Service.
Well, suppose there are two jobs. What can he, where's the dispute?
Well, Your Honor, I think Your Honor was about to ask what functions could he perform?
He has to be able to perform either one or the other job on your theory of it being two jobs. Now, there's plenty of evidence that Sports Service plus regards this as just one job where you assign people to different duties from time to time. But let's have it your way. Let's suppose it's two jobs. Where's the evidence that he can perform either one of them?
Well, Your Honor, I have two answers to that question. First, if the court agrees with me regarding having it my way and assuming that he...
I'm just trying to explore your position. I'm not making any statements.
No, I'm not saying that Your Honor is, but I'm saying if my position is assumed to be correct, then it must also be assumed that Sports Service has failed to meet its burden, and as the movement...
I don't see that. I mean, because your position must have some theory about what are the essential functions of the warehouse, based job, and what are the essential functions of the stands, the different places throughout the facility.
Yes, Your Honor. Well, the record, there are the two job assignments. They have different essential functions, except that they both share the function of keeping the work area neat and clean. And again, it's not that our expert decided that he can perform that, but Sports Service itself conceded that point. The interviewer,
But that's not the sum total of what you have to do in either of those locations.
Correct. There are other essential functions that apply to both work areas, but this brings me back to my initial point that the court cannot begin the analysis without identifying what those essential functions are. And that is the issue that Sports Service's own witnesses put into dispute. The commissary manager for Sports
I
Service.
don't see where the dispute is, to be honest. I mean, I think Sports Service has overwhelming evidence that there's actually only one job.
Well, Your Honor, here's the dispute. The job description, Sports Service maintains that what the job description says applies to all.
Right. Because they cross assign, because somebody would be doing one thing and then maybe a few weeks later they need them doing something else.
Yes, and so Sports Service insists that the essential functions apply to both positions.
Mm-hmm.
However, Sports Service's commissary manager points to these facts. While the job description says that one of the functions is to deliver food and beverages throughout the facility, the commissary manager says that only applies to concession porters. It does not apply to warehouse
Right. When you're
porters.
working in the concession, that's what you're doing. And when you're working in the warehouse, you're counting up the boxes, which you can't do, apparently.
But Your Honor, the assignments don't change randomly. It isn't a system where the employee comes to work one day with one assignment and then maybe later during the day they're given a different assignment, or maybe the next day they're given a different assignment. Instead, what happens is there's continuity of the assignments. When an employee is given the warehouse porter assignment, they spend all day inside the warehouse. And when they go home and then they come back to work the next day,
Well, I'll just point you to page 18 of the district court's opinion. He says, first, there is no evidence to support the contention that there are two distinct porter roles. Moreover, based on Washington's declaration, ISS appears to assign this function, that is to deliver the stuff, regardless of whether they are performing a concession assignment or a warehouse assignment, although it's most frequently a concession. And anyway, I mean, that you're
Your Honor,
maybe the district judge was wrong about that, but that's what the district judge finds.
we respectfully disagree with the district court. We urge this court not to make that same mistake. There is evidence in the record of these differences, and it comes from Sports Service's own witnesses. When the assignments take place, porters who are assigned to the warehouse, they can't leave the warehouse during their assignment.
But counsel, you don't contest the fact that the employer actually does cross-assign, right? You don't contest the fact that as part of the way they manage porters and scheduling porters, if they need a porter in concession and you're working in a warehouse, they can ask you to go work in the warehouse that day.
Your Honor, it is possible that they could do that, but there's no evidence that that's what they do.
I don't think
There's
that's
nothing
right.
in the
Isn't
record.
that, was it Mr. Washington, the person who was in fact a porter for quite a while? He testifies that they do both.
No, it's not whether they do both. It's whether the assignments change on the same day.
Well, not in 15 minutes, you know. But if it's Monday, you're in the warehouse, and they realize on Tuesday they need you in a concession. Doesn't that mean there's a cross assignment?
Your Honor, yes, it would mean there's a cross assignment, but the cross assignments don't occur the way Your Honor is describing them. There's a
That's all right.
continuity.
We can. I think we have your point.
Mm-hmm. Thank you, Mr.
I
Huff.
see my time has expired. Thank you, Your Honors.
Ms. Martin.
Good morning. May it please the court, Misty Mart on behalf of Appellee Illinois Sports Service. We're asking the court to affirm summary judgment because Mr. Shaw could not and cannot establish that he's a qualified individual for the purpose of the Americans with Disability Act. The fundamental issue in this appeal is whether companies should hire an individual who is not qualified for the job. The district court correctly held that there is no such obligation, and because there's no genuine dispute, Mr. Shaw is not qualified for the porter position. I'd like to address his...
Does it matter whether there are one or two porter positions in your view?
Not at all, because when you look at what the porters do on a daily basis, if you're a porter in the warehouse, you have to read and interpret warehouse delivery forms and the forms and the product that's coming off the trucks and the shipment. So if you're in the warehouse, you're doing that. If you are assigned to do the concession deliveries, you're reading inventory labels, delivery forms, and you're reading the product. And it's undisputed in the record that Mr. Shaw cannot do those two functions. So whether it's one or two, it doesn't matter because he can't perform the essential functions. And it should be noted that these two labels of a concession porter and a warehouse porter, those only came up in the deposition when counsel suggested, well, may I call it a concession porter when you're describing the assignment? It didn't come from Illinois Sports Service because you're correct. Mr. Washington said, if you're assigned to the warehouse, that's what you're doing that day, but you could be working in the concession if somebody calls in and they're sick or something to that effect. So as to the essential functions, I don't think there's a dispute as to what they are, and every porter is required to do them during their shift. Every porter has to read, every porter has to interpret forms and be able to look at the documents and interpret them. What we know about Mr. Shaw's limitations, unfortunately, which is undisputed in the record, he has severe impairments. You can look at the testimony of his own mother. You can look at the testimony of Ms. Hoban, speech pathologist, who worked with him for years, but at the time that he was applying, and she gave these examples. The porter is required to go to the warehouse and look at 500 different types of products and read the labels and read these forms and be able to know the difference between 10 different types of Goose Island beers. The record establishes that when Mr. Shaw is shown 6 basic functional words like comb, shoe, brush, and asked to point to the word brush, he cannot do that accurately all the time because of his impairment. Similarly, when you look at pictures, he's shown 6 functional pictures of a comb, brush, toilet, and asked which one would you use if you have to go to the bathroom. He couldn't point to the toilet as being the correct object. These things are undisputed in the record. So even if you take everything that the mother says that he's capable of doing at his house, you still need to look at the other evidence in the record from the medical providers, from the treating physicians, and from her own statements to the Social Security Administration regarding the disability benefits. And when you look at it as a whole, it's very clear, as the district court found, that there's no genuine dispute. It has to be a genuine and a material dispute. The fact that he can unload the dishwasher at home does not create a genuine dispute as to whether he is qualified under the Americans with Disability Act. The second factor, and we address it in a reverse way, but it's a 2-step analysis as to whether somebody is qualified under the American Disabilities Act, and the plaintiff has the burden of establishing it. The first step before you even get to essential functions is that you have to prove that you have the requisite skills. And plaintiff argued that there is a dispute as to what skills are required. It's undisputed that porters have to be able to read and interpret forms. It is in the job description. It's undisputed that porters have to do this every single day in their jobs, and it's not disputed. It's in their opening brief that Mr. Shaw can't do this. Because he doesn't have the requisite skills for the position, summary judgment can be granted and affirmed just on that first step, and you don't even have to get to the question of essential functions. And
the district court gave him the benefit of the doubt more or less in that first step, didn't he?
Yes, and I think that's a good point. The district court gave Mr. Shaw a lot of benefits of the doubt. A lot of the arguments that we made about what the expert was saying, the court considered all of that. When it came to whether he had the skills, the district court's opinion didn't specifically address like the skill of reading, so I think the court overlooked it. But you're right, he gave him the benefit of the doubt, but still found that he wasn't qualified under the Americans with Disabilities Act. I point to the skill of not being able to read and interpret as being one of the fundamental skills because it's so obvious that he isn't capable of doing it. There's other things that the record demonstrates that he's not able to do. So porters are required to report repairs. So if they go into a concession stand, they have to fill out a log and monitor that the temperature gauges of the freezer or the refrigerator. They do that in the concession stands, they do that in the warehouse. If Mr. Shaw does not do that correctly and he's not able to do it, there are important ramifications that happen. There's spoiled product that can happen because of it. So it's an important and essential function of why the company is requiring it, and the plaintiff hasn't established that he's able to perform those functions. So for these reasons, one, that he is not qualified and doesn't have the skills. Two, because even if you accept his two-porter argument, he still can't perform the essential functions. So we're asking the court to affirm summary judgment. Thank you.
Thank you very much, counsel. The case is taken under advisement. Coleman against the United States is next for argument today. Mr. Crickbaum.
Good morning, and may it please the court. My client, Frederick Coleman, filed a motion to amend his 2255 petition. That amendment related back to the original motion, and the district court committed a legal error when it concluded otherwise. I will begin this morning and focus this morning on that relation back issue. The two pleadings in this case made the same legal claim, and that was a claim of ineffective assistance of counsel. That legal claim arose out of the same core facts. The common transaction or occurrence here was, what did Mr. Coleman's lawyer tell him about the 851 notice, about the prior convictions that that notice relied on, and about the mandatory life sentence that that notice purported to trigger? Those issues were common, those core facts were common to both of his pleadings, which is why they were related to one another. And I think it's very helpful in this case and necessary to look at the specific sequence of events in the district court to see the relationship between the two pleadings. So the initial 2255 motion said that Mr. Coleman's counsel failed to inform him about the 851 notice. It talked about the prior convictions referenced in that notice and the mandatory life sentence. Now, the government, I think, interprets that to mean that Mr. Coleman was complaining that his lawyer failed to tell him about the existence of a single docket entry. But I don't think that's right. I think that ignores the requirement that the court should read this pro se pleading liberally. Mr. Coleman's complaint was not that he didn't get a PACER notification. His complaint was that his lawyer failed to give him adequate information and counsel about an 851 notice that purported to trigger mandatory life in federal prison. And I think that broader reading of the initial motion is confirmed by what happened next, which is that the government asked for an attorney-client privilege waiver. And it asked for a pretty broad one. The waiver was not limited to a single conversation on a single day about a single docket entry, but rather it applied to all communications between Mr. Coleman and his lawyer about that the filing of the 851 notice and about the potential life sentence. So when counsel provided an affidavit in response to the order from the district court, again, that affidavit was not limited to a single conversation about a single docket entry. The affidavit said that counsel told Mr. Coleman on more than one occasion about the mandatory life sentence. And then I think the key portion of that affidavit, counsel said, I informed Mr. Coleman that the mandatory life sentence was due to his prior criminal convictions. And I don't think there's any question. I think everyone agrees that that affidavit related back to the original motion. That was the whole purpose of the affidavit, was to respond to the motion. So then critically, when Mr. Coleman files his motion to amend, he says, in essence, I agree with what my lawyer...
Counsel, what is our standard of review on this question. The Supreme Court says that relation back is not allowed if the amended complaint, if the amended request, is supported by facts that differ in both time and type from those in the original. And the district court here found that they did differ in time and type. Are we supposed to make an independent decision, or are we supposed to evaluate whether the district judge made a clear error?
Review is de novo, Your Honor.
Why?
The reason is that the standard in Rule 15c is a legal one. Whether...
No, look, the Supreme Court has said more than once that if you have a dispute about the meaning of a law, the Court of Appeals gives an independent decision. But if you have a dispute about the application of a law to a particular set of facts, the Court of Appeals acts deferentially. This looks like an application of a legal principle announced by the Supreme Court to a particular set of facts. Why is that not reviewed deferentially?
Well, I think what the Supreme Court has said and what courts of appeals have said is that Rule 15a is a discretionary judgment, but Rule 15c is not. So, Your Honor, I would point the court to the Supreme Court's decision in Krupski, which we cited in our reply brief, where the court said, if the standard of Rule 15c is met, then relation back is mandatory. It is not within the district court's discretion. And the cases cited...
Look, counsel, I'm asking, what is our stance when we're deciding whether that standard has been met? We don't seem to have a dispute about the meaning of the rule. That's been settled by Mail against Felix. We have a dispute about the application of that rule to a particular set of facts. Right? Do you have some Supreme Court case that would say the Court of Appeals reviews that independently?
I don't have a Supreme Court case, Your Honor, but we've cited in footnote 1 of our reply brief a number of courts of appeals decisions that say that Rule 15c is ultimately a legal question.
I think this is just missing the nature of my question.
Well, Your Honor,
you can proceed.
What those courts of appeals have said is that the review of the district court's application of that legal standard is reviewed de novo. I think that's what...
Well, then there's a problem with the Supreme Court because the Supreme Court has held otherwise.
Well, I guess I'm not sure I'm going to be able to satisfy you this morning, Judge Easterbrook. I would say I would point the court to the Supreme Court's decision in Krupski and to the cases we cited in footnote 1. And I would draw a distinction between Rule 15a, which rests in the district court's discretion, and Rule 15c, which is a legal standard, and the court reviews the district court's application of that legal standard de novo based on the cases that we've cited. Returning to the merits of the relation back issue, what Mr. Coleman said in his motion to amend is, I agree with what my lawyer said in his affidavit. That is what he told me. He told me that because of my prior convictions, I would get mandatory life in prison. And that's wrong. That's inadequate information. That's inadequate legal advice. That is, in fact, a legal error because the prior convictions did not qualify for the mandatory life sentence. So I think here there is a straight line between the motion to amend and counsel's affidavit and the original 2255 motion. I think each of those filings relate to one another, and I think it follows that the motion to amend relates back to the original motion. I think both parties in this case agree that the key issue here is fair notice. Did the government have fair notice about what it was going to have to litigate in this case?
It strikes me as a line-drawing issue. I mean, relation back, which is why I understand why Judge Easterbrook is concerned about the factual aspect of this. It's supposed to be the same in time and type, but these things are not light switches. It's not just a binary, oh, this is the same and this other thing's different. They come in all shades of gray. And how broadly is that relation? I can certainly see the second thing that he files, the motion to amend, as elaborating, especially on the affidavit. I mean, the first thing is pretty cursory, but you make the valid point that they're both pro se filings. We have Erickson against Pardis. We have other cases that have reinforced the leeway that you give to pro se individuals. But on the other hand, you also give some deference to the way the district judge interprets this. Was anybody who looked at that first motion aware that this whole, Taylor and all this other line of cases, Ruth hadn't even come out yet, so, good for Mr. Coleman, whoever he was being helped by at the prison, to spot that this issue about positional isomers, was going to somehow going to come up. But it's hard from a notice point of view to realize that there was notice to the United States with that first petition. Maybe the notice to the United States is perfected by the time the motion to amend comes along, but like what tucks under the broad category and what becomes just different enough from an evidentiary, from a notice point of view, from a type of evidence point of view to make it either an error of law or an abuse of discretion, either one, in refusing to relate back.
So I agree with you, Judge Wood, that answering that question in the abstract is very difficult. There are some guideposts, and you've focused on notice, and there's still an abstract question there about what is sufficient notice. I agree that I would admit that from the initial filing, it would not necessarily be obvious to the government that they would be litigating about isomers. I agree with that.
I think it came as a surprise to some people, even in Ruth. So
I think that's a fair statement, Your Honor. However, what I do think the initial filing gave the government notice of, and this was sufficient, was that they had to litigate about the sufficiency of all of counsel's communications and advice to Mr. Coleman about that 851 notice, the prior convictions it relied on, and the life sentence. And certainly by the time we got to that affidavit had better have related back to the original motion, or else there was a improper waiver of attorney-client privilege here, and privileged communications were improperly disclosed if there was not a close relationship. And when Mr. Coleman then takes that affidavit and in response says, yes, I agree, this is my complaint, that what my lawyer says he told me is not adequate under the Sixth Amendment and in fact is wrong, I think the government can't claim surprise that Mr. Coleman relied on the affidavit that the government asked for. That can't be an unfair surprise. So while I can't answer your question probably sufficiently in the abstract, I do think given the sequence of events in this case, you can reach a narrow ruling on that issue. If the court does not have questions about the merits, I will rely on our briefs there. I do think the most narrow ground on which to reverse here would simply be to reverse on the issue of relation back and remand to the district court for consideration of the merits in the first instance. And so if the court were interested in deciding this case on a narrow ground, that would be our suggestion. If there are no additional questions, I will reserve the rest of my time for rebuttal. Thank you.
Mm-hmm. Mr. Simpson.
Thank you, Your Honors. May it please the court. I'm Scott Simpson on behalf of the United States. Before I start my argument, if I could just say a few words about the Harris decision and how we handled that in our brief in this case. There's some language kind of in the Harris decision that goes both ways. It says 3 times that the argument later accepted in Ruth was a novel argument, that it was too unprecedented to merit discussion with the client. But it has other language too that would point in the other direction. And in retrospect, we do wish we had included the fullness of that discussion from Harris in our brief to give this court a fuller understanding of the Harris decision. So we do regret our oversight in not discussing the opinion in full. I'm glad to communicate that to the court today. So first of all, on the standard of review, the order under review here, of course, was the denial of a motion to amend. And it's clear that the standard of review on denial of a motion to amend is abuse of discretion. We see no reason for a different rule where the denial of the motion to amend is based on a relation back analysis. Granting or denying, as Judge Easterbrook has commented, granting or denying a motion to amend will often turn on applying law to fact. And the decision on relation back is no different in that respect. Mr. Coleman takes the position that the district court made a legal error here, but again, the district court in this case did not settle any question of law. It simply applied the established law to the facts of this case. But in any event, all of that having been said, the proper standard here really, we think, doesn't matter because the district court's denial of the motion to amend in this case should be affirmed, even if under de novo review.
But even if it's an abuse of discretion review, this is certainly not a situation where the first version of the 2255 motion said, you know, I'm raising ineffectiveness of counsel for failing to, you know, pursue a Batson challenge, and then the second thing said, I'm pursuing it because I didn't get adequate notice of the 851. I mean, those are completely different things, we understand, and most of the cases that we see look more like that than look like this case. This is a close relative of what's in the first motion, and the first motion looks in that respect kind of like a placeholder. You know, I didn't get the 851 notice. And then the natural question would be, well, why does that matter? And the reason it matters is what's fleshed out in the second, in the request to amend. Maybe that goes to prejudice, maybe it goes to certain other things, but it's not really a shift of theory. It's who cares whether you got notice of the 851 or not? You knew what your priors were, you know, you knew this. And I'm concerned about that because it seems that it's awfully close, and it depends on how close do we need to be in order for it to be an abuse of discretion, as you would have it, to refuse the amendment, particularly with the overlay that he's pro se, the Erickson overlay, you know, whatever you want to, whichever case you like to cite for giving some leeway to pro se litigants.
Well, Your Honor, it's really, I think Your Honor's question really goes to two different issues. The first one is the standard of review here. I'm trying to say, for the sake of argument, let's make it abuse of discretion. I don't want to hover on that any more than we already have. Certainly, Your Honor. So going on to the relation back, and I acknowledge that it is closer than some cases, such as the Batson scenario that the court has mentioned. But really, these the claim made in the original motion is really of a different type than the claim that he tried to raise in the motion to amend.
Why is it a different type, though? It's the same 851 motion.
Well, Your Honor, if you look, and I looked again just now at the original motion, and it says that the main claim there is that his counsel failed to inform Mr. Coleman of the 851 notice enhancement provided by the government. And it is important. It is important to communicate, obviously very important to communicate with the client. I think any state disciplinary bar authority would tell us that one of the most common complaints against attorneys is failure to communicate. And failure to communicate would be a valid, conceivably valid basis for a claim of ineffective assistance. But this goes beyond that. It's rather than failure to communicate, it's a substantive claim, a failure to conduct research, which is what it would require. In his reply brief, Mr. Coleman, it's in a footnote, says that the claim of a failure to conduct research was merely subsidiary, and I think counsel today has made basically the same argument.
Mr. Coleman was saying that if the notification had come to him, he would have done his own research, which is what he did. He actually did a pretty good job, actually.
But, Your Honor, the notification...
and without notification, he didn't have the tools he needed to do his own research.
But he did receive notification. He did receive notification that the government was planning to rely on prior convictions. What the motion to amend tries to add to that is not communication but research. It's of a different character. One can communicate without conducting research, obviously, and one can conduct research without communicating. We only need to look, I think, at the nature of Mr. Coleman's merits arguments in this case on appeal to understand the nature of the claim that he was trying to add to his Section 2255 motion. Of course, Mr. Coleman is now arguing relation back in order to make the merits argument that he's now making on appeal. And that argument is focused on researching, is focusing on anticipating Elder and Ruth and the other decisions that go along those lines, and coming up with what this court in Harris called a novel argument regarding drug definitions. That argument focuses on what Mr. Coleman did or did not do back at the office, not on what he did or did not do in communicating with Mr. Coleman. And it's the same, you see the same thing in relation to how the government would have had to respond to that. In responding to a complaint, my attorney didn't communicate with me. You look at the facts. Did the client communicate? Or, as the district court found, did the defendant get that information in some other way at the hearings? Responding to the new claim, however, would have required the government to address the legal questions that we're now dealing with on the merits in this appeal. That is, should the attorney have anticipated Ruth and Elder and so forth? So a few words on the merits, Your Honors. Under Strickland, of course, the defense has to show both constitutionally deficient performance and prejudice. Now, Harris commented some on that deficient performance issue and made comments in both directions. Importantly, though, Harris didn't say anything about the prejudice prong. Especially in this case, though, really the deficient performance analysis under Strickland and the prejudice analysis under Strickland are very closely related. In light of the case law as it existed in 2014, when he was sentenced, Coleman's attorney surely didn't render unconstitutionally deficient performance by failing to make what Harris called an unprecedented argument.
But we've been a little inconsistent in that, because in some instances we've said that it really wasn't such a novel argument. You can go all the way back to Taylor, and you know that you have to compare and you have to see what the relation is between the state laws. And then there's some cases that say, but at this granular level, nobody had even thought of it. But that's probably on us if we haven't been as clear as we should be. But in principle, you would say the government comes up with its proposed enhancers in the 851 notice, and the first thing defense counsel should do is say, are these appropriate under the statute? And let's compare.
A couple of responses to that, if I could. One of them is on page, I think it was 23 of our brief. We cite two decisions, page 23. We cite two decisions by this court, unpublished decisions. One of them from 2011, holding the one in 2011, United States versus Jackson, held that a conviction for possessing 15 grams of crack cocaine under 402C of the Illinois statute constituted a felony drug offense.
But there's a reason they're non-precedential. They don't go through the full vetting that we're doing right now, for example.
And I think the core of our point, Your Honor, is that total vetting really didn't start until Elder. The basis for besides Taylor, but
which goes way back.
Correct. But the analysis that ultimately ended up in De La Torre on methamphetamine and on cocaine in Ruth really began with Elder. Just a few months earlier, just a few months before Elder, in Brock Miller, the court expressly declined to address even whether to apply the categorical approach to the question of felony drug offense. The state said in Elder that determining whether a given state conviction qualifies as a felony drug offense under 802.44 is a question of first impression. So are we saying that we should require counsel to provide merely constitutional, that's a low bar, constitutional effective, constitutional performance, that they should anticipate that kind of thing? When Coleman was convicted in 2014, there was, of course, no direct precedent holding that the statutes didn't match because of the Illinois and federal definitions of cocaine. And at that time, 2014, there was not even any direct precedent holding that the categorical approach applied at all to that question. Mr. Coleman's opening brief on this appeal admits that it's not clear that any defense counsel, and by that they mean any defense counsel anywhere in the country, had even advanced a Ruth-type argument when Coleman was sentenced in 2014. And in fact, as we say on page 53 of our brief, at least 2 district courts in this circuit, these are 2 decisions from 2021, Williams versus United States from the Central District of Illinois, and Neal versus United States from the Southern District of Illinois. Those 2 decisions, and of course those district judges had seen firsthand the work of the defense counsel before them. They squarely held that those attorneys did not provide ineffective assistance by failing to make a Ruth-type argument during sentences in 2017. Sentencings in 2017 and 2018.
There were cases, though, in other circuits where the circuit courts applied the categorical approach to ascertaining the match between the state conviction and quote-unquote felony drug offense. Isn't that correct?
Correct, Your Honor. Correct.
And so I think these are some of the cases are listed in the Brock Miller case. There was a First Circuit case in 2007, United States versus Brown. There was another case out of the Fourth Circuit in 2007, Fifth Circuit 2005. And so when we're dealing with here a potential life sentence, if counsel were to research whether or not a circuit court, not even district court, but circuit courts across the country have applied the categorical approach in ascertaining what felony drug offense means, he would have had those cases.
Correct, Your Honor, and I think that's why, aside from the deficient performance prong, we need to look as well at the prejudice prong. Even aside from the deficient performance prong, we have to look at whether there was a reasonable probability that the result of the proceeding would have been different if Mr. Coleman's attorney in 2014 had done that kind of thing. Let's say that he had done that kind of thing and he had brought that argument. That would be before Elder. That would be before Brock Miller.
But we frequently say somebody's case has to be the first one.
But it would have been a great leap, Your Honor, and what we're saying here is that was there a reasonable probability in 2014, was there a reasonable probability that that argument would have succeeded? That's what the defense has to show here. And I just can't imagine we would say that there's a reasonable probability that he would have succeeded, so he was ineffective constitutionally. So we urge the court, Your Honors, to affirm the denial of the motion to amend, or alternatively to hold that Mr. Coleman has failed to show ineffective assistance. Thank you.
Thank you, counsel. Mr. Crickbaum, anything further?
Thank you, Your Honor. 3 points. First, on the standard of review, in our reply brief, we cited the Alani's case in footnote 1. That's a Fifth Circuit case, noting that 11 of the 12 courts of appeals applied de novo review to relation back questions. This court should be reluctant to depart from the near consensus approach there. Second, on the substance of relation back, Judge Wood, you said this is awfully close. And I think that's true, and I think this court should apply 2 levels of leniency here. The first one is in Rule 15C, which says that dispositive decisions should be based on the merits. That is a long-held principle of the federal rules of civil procedure, and it applies in 2255 actions. And the second reason, Judge Wood already noted, Mr. Coleman is a high school dropout who wrote these petitions by hand from a federal prison, and his words should be interpreted liberally. When they are, there is enough here to find that the motion to amend related back. Whatever differences there are between these two pleadings, those differences should not determine whether Mr. Coleman must spend the rest of his life in federal prison. That sentence should not turn on trivial distinctions between these pleadings. Lastly, on the merits, I would encourage the court to look to Harris. Judge Wood, you noted that some of your decisions perhaps could be read in multiple ways on this issue. I think Harris is clear. Harris said in 2017, a minimally competent defense lawyer should have known about this argument. And nothing was different 3 years earlier in 2014 when Mr. Coleman was sentenced. The only difference in Harris is counsel in Harris had...
Counsel, are you then surprised that we held in White in 2021 that Ruth is not retroactive? If it's just a simple application of Taylor, and every reasonable lawyer should have known that, why doesn't Ruth reach at least back to 1991? But White holds that it's not retroactive at all. I just wonder how that's consistent with the position you're taking now.
Your Honor, I have not thought about that question, but
What's going on here fundamentally is you're trying to use the ineffective assistance doctrine to make Ruth fully retroactive, even after the Seventh Circuit has held that it's not retroactive.
No, Your Honor. If I could briefly address that question.
Please do.
Well, I think what you're getting at is, could someone file a second or successive 2255 petition?
It has nothing to do with second and successive petitions.
Well,
the decision is retroactive or not in a first petition. And White holds not.
Though White said that the roots of Ruth go back to Taylor in 1990.
No, White holds that Ruth was a novel decision and therefore not retroactive.
I disagree, Your Honor.
I know you disagree. Your whole position is there's nothing remotely novel about Ruth.
And White said that, Your Honor. White said that this mismatch argument was not novel. Those were the words of White. This argument is not novel. Thank you, Your Honor.
Thank you very much. And Mr. Crickbaum, we appreciate your willingness and that of your law firm to accept the appointment in this case and your assistance to the court as well as your client.
Thank you.
The case is taken under advisement. Our final case of the day is United States against Larry. Mr. Carlson.
May it please the court. My name is Kent Carlson, and I'm court-appointed counsel for Torrance Larry. Although I've raised two issues in our brief, I intend, unless the court asks other questions, to focus on the in furtherance language in 924C.
Well, I'm glad you're calling it 924C because your brief calls it 924 copyright symbol over and over and over and over, raising, in my mind at least, the question whether you edited it after you dictated it.
I apologize to the court for that. I did not intend on that happening, and I will...
You just look at it, and it says 924 copyright symbol over and over. How can this brief have ever been reviewed?
Judge, I apologize. I have nothing else to say other than I apologize for that. The connection between the firearm and the charged offense has to be more, it can't be a non-theoretical tie to the offense. It's got to be a concrete tie to the, between the firearm and the particular offense. And in this instance, the drugs and gun were located, although in the same room, in fact, very close to each other. It is clear from the dealings with the confidential informant that Mr. Larry's drug distributions occurred not in the bedroom, but in the living room, and that he never observed Mr. Larry with a firearm during any of those transactions. Firearm was merely unloaded, sitting on a nightstand in his bedroom, and there is no evidence that that firearm was connected to any of the drug dealings. The confidential informant said he never saw a gun, and what we know is that the jury was instructed pursuant to the factors that have been often cited and started with back in the Fifth Circuit, but this court in United States versus Brown questioned the relevance of many of those factors, and in fact said many of them did not make a whole lot of difference in connection with things, and that the facts of the case really are what needed to control. And I suggest to the court that the facts herein do not show that this gun in any way was involved in or furthered the drug transactions that involved the confidential informant, and that it was merely present in the same room with the drugs with no further connection.
But the definition of in furtherance of is a pretty generous one.
It is a generous definition.
I mean, you have to show that it's really not related, don't you?
Judge, I don't believe that it goes that far. I think the standard is that the government has to show that there is a real connection, not some theoretical connection between
and
the
here,
parties.
the gun is sitting on the nightstand. The loaded magazine is right there. There's testimony that it was just a matter of seconds to pop it in.
Well, Judge,
and the drugs are right there. I mean, it's a fairly small place. This is not, the Taj Mahal. It's a little trailer.
That's correct. A couple of things, though, Judge. Number one, there were more than one magazine there. There was either 3 or 4, depending upon.
I'm not sure that helps him, but yes, that's right. I remember that.
But my point is just it sounds great to say that it could be quickly loaded, but you have to know which magazine went in the gun, and there's no evidence that that was something that he knew. Additionally, one would think that if you were conducting drug transactions and the purpose of the firearm is to protect you and or your drugs during the transaction, it wouldn't be in a different location than when where the transactions come down. If you're concerned that you're going to get robbed, you're going to have the firearm with you. Or if you don't have it in the beginning, when you go back to get the drugs out of the bedroom, you come back with the gun. There's no evidence of that. And as a matter of fact, again, this confidential informant said he never saw any weapon. So I suggest, and I think the case law says, mere presence of the weapon in close proximity with the drugs in and of itself is not enough. There's got to be something more, and I suggest to the court that more is not present here. Unless the court has any questions, I don't have anything else at this point.
Mm-hmm. Thank you, Mr. Carlson. Mr. Holler.
Good morning, Your Honors, and may it please the court. Sufficient evidence supports the jury's conclusion that Mr. Larry intended to distribute the cocaine and methamphetamine in his bedroom nightstand, and that the gun in the same nightstand helped further his drug activity. This court said in the Stevens decision in 2004, if the drugs and gun are found in the same place, it is nearly an inescapable conclusion that they are connected for Section 924C purposes. I'm aware of no decision in the last 19 years that has retreated from that. The standard here is whether any rational juror could have found beyond a reasonable doubt that these two were connected. If this court thinks it's nearly an inescapable conclusion, it seems to me entirely clear that a rational juror could have made that finding. The gun, if the court has any questions, Exhibit 13H shows just how small this nightstand was. The gun, the magazine, and the drugs are all inches from each other, next to the point where the defendant was sleeping at the time the agents entered to execute the search warrant. I do not know if Mr. Larry had a gun with him when he sold the drugs to the confidential informant. He had a holster in his room. It's very easy to conceal weapons in your waistband or in a holster and have them with you and not parade the gun in front of the person you're selling the drugs to. I don't know that any of that matters. Stevens alone decides this case. If the court has any further questions on that or the drug issue, I am happy to address them. Otherwise, I'm also happy to give back the balance of my time and ask that you affirm.
I see no questions. Thank you. Anything further, Mr. Carlson?
No, Your Honor.
Well, Mr. Carlson, the court appreciates your willingness to accept the appointment in this case, which is taken under advisement. The court will be in recess.